Denver County Court Virtual Advisements. Temporary Protection Orders. Good morning. You are all here because you have filed a request for a temporary protection order. Your petitions will be read through. In some of your cases, enough information may be found to grant your order. In other cases, some additional questions will be asked. Each individual will be called up to the podium, at which time you can ask questions, but first, an advisement about the process will be given. The court has the authority to issue a temporary protection order to prevent the following: 1. Physical assaults, threatened bodily harm. 2. Domestic abuse, including domestic violence. 3. Emotional abuse of the elderly or at-risk adults. 4. Sexual violence and stalking. In order to issue a temporary protection order, the court must find 1. A risk or threat of physical harm exists to you. 2. A threat of psychological or emotional harm exists to you. The purpose of this courtroom is to protect people from suffering physical harm or serious emotional distress. This court does not handle evictions, property disputes, defamation, or divorce matters. If a temporary protection order is issued in your case, the other party will be prohibited from having any contact with you until the next scheduled hearing regarding the question of whether the protection order should be made permanent. The other party cannot contact you directly, and they cannot have a third party reach out to you on their behalf. Additionally, they cannot call, text, email, or have in-person communication with you. They will also be ordered to stay 100 yards away from you at all times. If you included your home and/or work address, they will also be ordered to stay 100 yards away from there as well. This order will remain in place for the next 2 weeks, or until the next hearing where the other person can be here. If your circumstances do not meet these requirements, it is required by law to deny your request for a protection order. If a protection order cannot be issued today, please know that does not preclude you from calling the police for your safety. The police should always be your first point of contact for safety concerns with or without a protection order. Also, it does not preclude you from coming back to court to request a protection order in the future if circumstances change or escalate. If a protection order is issued today, you will be provided a packet of information when you leave. This will include a copy of the protection order. If a temporary protection order today is issued in your case, the first thing you must do is get the other party known as the respondent served with the temporary protection order. The temporary protection order cannot be activated unless it is served on the respondent and an affidavit filed with the court. Service simply means that the temporary protection order and any related documents have been personally given to the respondent so that they are aware of the temporary restraining order and that they have an opportunity to come into court to respond. You are responsible for serving the respondent. It can be done in one of 3 ways. 1. You can have law enforcement serve the respondent. 2. You can hire a professional process server. 3. You can have anyone over the age of 18 that is not involved in the case serve the respondent. The temporary protection order cannot be activated until the respondent has been personally served and a return of affidavit has been filed with the court. The return of service (ROS) affidavit is simply a form that must be filled out by the person who served the respondent, swearing under oath that they served the respondent on a particular date, time, and location. This often may include a physical description. If you are able to serve the respondent here in Denver, you can use the Denver Sheriff's Department. DSD is located in the Webb Building across the street. If you are able to use a sheriff, they will complete the return of service affidavit and file it with the court on your behalf. The benefit to using a law enforcement or a professional process server is that they have experience doing it. They have databases to help find people. They will file the ROS affidavit with the court. If you chose a private process server or to have someone over 18 serve the respondent, they must fill out the ROS and give it to you, and you will be responsible for filing that ROS affidavit. Whatever method you choose, you are strongly encouraged to start now because the case will be set for 2 weeks from now. That is, all the law allows, 14 days from the issuance of the temporary protection order. If the other party contacts you before you have been able to get service, you can call the police. If that person is still on scene, the police are required to personally serve the temporary protection order at that time. Please understand that even if a temporary protection order is issued today, that does not necessarily make it permanent on the next date. If your request for a temporary protection order is granted, it will be based on the sworn statements that you made today in your petition. The reason the law allows for a temporary restraining order to be granted is to provide immediate protection from the threat of physical, psychological, or emotional harm. But when we have the hearing to determine whether or not it will be made permanent, there is a different inquiry. You, as petitioner, will have the burden of proving the following by a preponderance of the evidence. 1. Acts alleged in the petition occurred. 2. Unless permanently restrained, the respondent will continue doing those acts and/or intimidate or retaliate against you. For the hearing, the respondent is going to be present. You will be entitled to present your side, and the respondent will have an opportunity to be heard. You each will have a right to testify and to present their own witnesses. You each will have the right to cross-examine the other side's witnesses, meaning the right to ask questions. Not all temporary protection orders are made permanent. This is because many more facts and information come out at the hearing which help the court understand the full context of what happened. A permanent protection order is permanent. It has potential long-term impact on the respondent, including potential impact on employment, housing opportunities, as well as immigration. If your matter involves sexual violence, you will have the burden of proving by a POE. 1. The respondent committed acts which constitute grounds for the issuance of a permanent protection order on the basis of sexual violence. 2. There exists a risk or threat of physical harm to you, or there exists the threat of psychological or emotional harm to you. If your request for a temporary protection order has been granted, your case will be set 2 weeks from now at 10:30 a.m. During the next 2 weeks, please be thinking about what you will need in order to prove that the respondent committed the acts you have put in the petition. So, how is that done? 1. Testify on your own behalf. 2. Bring in witnesses who have direct knowledge of what happened. Letters cannot be accepted. Witnesses need to be present. Exception. If your witness is out of state or has physical or other limitations, you can ask for permission for them to appear via video. This must be done 48 hours before your hearing. If you need to issue a subpoena, we can help to give you the subpoena, but the court does not serve it on your witness. You can either get someone over the age of 18 and not part of the case to serve your witness, hire a private process server to serve your witness. If your witness is cooperative, that person can sign a waiver. 3. Physical evidence, such as pictures, text messages, audio recordings, video recordings. Mark each piece of evidence and bring 3 copies. The evidence must be in a form that the court can keep. If it is digital, you need to bring a storage drive. Bring a laptop or whatever you need to play your digital evidence. We have equipment, but you can't be sure that your drive is compatible with our system. You are welcome to hire a lawyer. It is obviously advantageous, but you certainly don't have to, and many people represent themselves. You and your witnesses must appear in person. You will need to be on time and ready to go. Please recognize that this is a limited resource. The court needs to determine if the acts occurred and if the respondent will continue to commit those acts if not restrained permanently. Provide enough information to help the court understand the context in which the need for a temporary protection order arose, and for the court to understand whether it needs to be permanent. Now, if you have not served the respondent by that date, that is okay. You still need to come to court. Please make sure to be early or on time. If you don't appear by 10:45 a.m., it will be assumed you are no longer wanting to pursue a permanent restraining order and the case will be dismissed. So even if you haven't gotten service, please show up. If you are able to show that you have been trying, a 2-week continuance may be granted. There are 5 different options for what could happen on the next date. 1. Continuance. Be ready, but you need to be prepared that there could be a continuance. Why? The respondent just got served and needs some time to hire a lawyer, and you might decide you want a lawyer. Only 1 continuance will be granted to either party if someone asks for additional time to hire a lawyer or because they need time to get evidence. 2. Someone doesn't show up. If the respondent doesn't show up and they have been properly served, then the temporary protection order becomes permanent. 3. Respondent agrees to make the order permanent. 4. Hearing. 5. Parties agree to continue the temporary protection order for up to a year. There are benefits for this year temporary protection order. You don't have to present your case and risk the court finding that you didn't prove your case. If we go to hearing, one side wins and one side loses. If you extend the temporary protection order, you get the same protections as a permanent protection order. Everything is the same. Penalties for violating are the same. The benefit to the respondent is that it is an opportunity for them to show that they can comply and stay away from you for a year. Another benefit is that it doesn't go on their permanent record. This will only occur if both parties agree. If a finding that your underlying relationship involves domestic violence, meaning you have at some point been in an intimate relationship with the other party, then a Brady advisement will be provided. Any firearms in the respondent's possession or control must be relinquished. Part of your packet will include that information. You will be given 2 dates. 1. The permanent protection order hearing date. 2. The date on which the respondent must show up or provide proof that he or she has relinquished. The court will adhere to the Colorado Rules of Evidence. For example, if a piece of evidence isn't relevant, it won't be admitted into evidence. Not every piece of evidence that you bring will be relevant to the court's decision. Example, financial arguments is not something that needs to be heard. If it isn't relevant, it cannot be considered. Likewise, the court isn't going to consider hearsay. Hearsay is a statement made outside of court that is offered to prove the truth of the matter asserted. As an example, let's say that 3 days later, if you told a friend about what happened, but that friend wasn't present, your friend won't be allowed to come in and testify about what you told them. There are hearsay exceptions, of course, and we will cross those bridges when we get there. If this matter involves domestic abuse or violence, you may also seek assistance from Project Safeguard or the Rosandom Center. Both are nonprofit agencies which provide assistance and services to victims of domestic violence. A clerk can help you with information regarding these services. You have the right to come watch a hearing here anytime. You have the right to counsel. The court cannot give you legal advice, but it is encouraged to look at the law in your case. See what the court must apply in order to make the temporary protection order permanent. Keep the order with you at all times. Thank you for your attention during this advisement.